Homeowners associations. Love 'em or hate 'em, right? They're supposed to keep things orderly, but man, sometimes they're the ones starting the drama. Today, we've got a really wild story for you. It's about a homeowner who decided to take on his own HOA. But here's the kicker. He was also on the board. Yeah, let's dig into how a simple project turned into this huge legal mess.
So that really brings us to the core question here. What happens? It's a story about rules, power, and this just bizarre conflict of interest that put one guy on both sides of his own fight. And believe it or not, it all kicked off with a pretty simple, unapproved home improvement project.
All right, let's set the scene. Our story kicks off in a way that probably sounds familiar to a lot of you. A change was made to a property, but nobody got the okay first.
So we're talking about changes to the common areas here. The spaces everyone shares. This homeowner, Lawrence Stewart, just went ahead and made these changes without getting permission from his condo association. I mean, that's a pretty clear rule violation, and you can bet the HOA was not going to just let that one slide.
And this thing escalated fast. We're talking just a few months. It starts in November 2017 with a totally normal violation letter. Then in December, Mr. Stewart asks for a variance, which is basically just asking for an exception. By February 2018, things got super tense at a board meeting. We'll get into that in a second. And by May, this whole thing had blown up and moved into the legal system. Stewart actually filed a petition against the very association he was a part of. Okay, and this is where the story gets really interesting. Because Mr. Stewart, he wasn't just some random homeowner trying to get out of trouble. Nope, he was one of the people in charge. I mean, this is the heart of the whole mess, right? As a homeowner, Lawrence Stewart straight up broke the rules. But as a board member, he was one of only 3 people whose job it was to enforce those very same rules. So you have this totally wild situation where he's asking his 2 colleagues to give him a pass on a rule he was supposed to be upholding. Talk about wanting to have your cake and eat it too. Just try to picture this for a second. You walk into that meeting. You're not just the homeowner who's in hot water. You're their colleague. You're sitting across the table from Sandra Fernandez and David Larson, the people you make decisions with every day. But now you're pleading your own case to them. Wow. The tension in that room must have been off the charts. And, according to the official documents from the hearing, Mr. Stewart felt it right away. This quote really says it all. He just got the sense that their minds were already made up. So, feeling like he wasn't going to get a fair shake, he does something pretty dramatic. He resigns from the board. Right then and there. And just moments later, his now former colleagues officially voted to deny his request. Oof. So what was the board's official reason for saying no? Well, it was the classic Pandora's box argument. You've probably heard it before. They were worried that if they gave an exception to one of their own, everybody would start asking for one. In their minds, they weren't just denying him. They were protecting the rules for the whole community. But Mr. Stewart, he was not seeing it that way at all. He felt like he was being treated unfairly, so he decided to take this thing to court. And he built his entire case around one very specific little phrase in the HOA's own rule book. Okay, so at the core of his whole lawsuit was this one rule, Bylaws Section 5.4. Now, rules like this are super common in HOAs. The whole point is to protect volunteer board members from getting sued personally for the decisions they make, as long as, and this is the key part, as long as they're acting in good faith. It's basically a defensive shield to give these volunteers some peace of mind. And Stewart's entire argument hung on that one little phrase, good faith. He was saying that since the board, in his opinion, didn't even fairly consider his request, they had not acted in good faith. He thought this bylaw with his ticket to sue them for making a bad call. So this all lands in front of an administrative law judge who, let's just say, had a very different take on what that bylaw was for. And the judge's whole viewpoint can be summed up with this really great metaphor, a shield versus a sword. But wait, before we get to that metaphor, let's just quickly talk about a super important legal idea, the burden of proof. See, in a case like this, the responsibility was all on Mr. Stewart. He was the one who had to prove his claims. It wasn't the HOA's job to prove they acted in good faith. It was Stewart's job to prove they acted in bad faith. And trust me, that is a really, really high bar to clear. And this slide just nails the judge's thinking. Bylaw 5.4 was written to be a shield. It's a defensive tool to protect the board. But what Stewart was trying to do was use it as a sword, an offensive weapon, to drag the board into court and force them to defend their decision. The judge was basically like, nope, that's not what this rule is for. You're reading it all wrong. So the judge broke it down very logically. Step 1, this bylaw is a shield, not a sword, which means it doesn't even apply to what Stewart is trying to do. Step 2, therefore, it's not applicable. But the judge went even further. He said, look, even if it did apply, the board's whole Pandora's box worry was a perfectly reasonable reason to say no. And then, the final nail in the coffin, Stewart just didn't bring the receipts. He didn't meet his burden of proof. Now, you'd think that's the end of the story, right? Wrong. Mr. Stewart actually got a rehearing, a second shot at making his case. And this time, he came back with what he thought was a smoking gun, new evidence that this was all about personal bias.
So what was this new evidence? Well, there were two main things. First, he had this pretty nasty letter from his old board mate, David Larson, that went out to all the homeowners telling them not to vote for Stewart in the next election. Ouch. Second, he brought in a bunch of photos of other condos that he claimed were also breaking the rules, basically trying to prove he was being singled out.
But it wasn't enough. The judge wasn't convinced. Yeah, that letter from Larson clearly showed there was some bad blood there, but it didn't change the core legal issue. Stewart was still trying to use a shield as a sword. And the photos? Well, Stewart himself had to admit he didn't actually know the backstory on those other properties. I mean, for all he knew, they got approval years ago. Without that context, the pictures didn't prove anything. And that, my friends, brings us to the final verdict and some really important takeaways from this whole messy situation.
The verdict was clear and final. For the second time, the judge dismissed Lawrence Stewart's petition. It was over. After all that, the meetings, the resignation, 2 different hearings, the HOA board's original decision stood.
So what can we all learn from this? Well, a few big things. First, trying to prove an HOA board acted in bad faith is incredibly difficult. It's a huge uphill legal battle. Second, that Pandora's box argument, turns out it's a pretty solid, legitimate reason for a board to make a decision. But the biggest lesson, for sure, is that shield versus sword idea. A bylaw meant to protect the board can't just be turned around and used as a weapon against them. And lastly, if you're going to cry foul and claim you're being treated unfairly, you better come with more than just some pictures and a hunch. You need actual, concrete proof. Wow, what a case. It just goes to show how complicated and messy things can get when you mix personal beef with community rules. It really shines a light on the tough spot these board members are in, especially when they have to police their own friends and colleagues. It really makes you wonder, doesn't it? After hearing all this, would you ever sign up to be on your HOA board?